This is attorney Mark Nicholson. I'm here with Audrey Lunsford, an attorney as well. And this is the Circle City News. Today, we're going to talk a little bit about the trial process. Some people ask us, what's it like going to trial? What happens at a trial? And we often see trials on TV, right?
Mm-hmm.
You know, you see these trials, and most trials on TV, they last like one day. And well, you know, there are these real trials that you see that, you know, and on crime TV or court TV, I think it is, where they last, you know, days and days. And you can see that. And there's obviously the O.J. Simpson trial that people watched the last weeks, or this Johnny Depp trial.
I was going to say Johnny Depp, Amber Heard.
Yes. So those are real trials,
Mm-hmm.
right? These are real trials and not the TV show type of trials that last, you know, 20 minutes, 30 minutes, and, you know, there's a verdict and all that kind of stuff. And oftentimes you know what the verdict is. In real life, when there's a trial, and I'm talking specifically about a criminal trial, an adult criminal trial, when the attorneys are preparing for trial, there's a lot of motions that are filed before the case actually goes to trial. All these negotiations, plea negotiations, pretrial motions, try to keep stuff out or get stuff in. There's all this stuff going on when it comes to the trial. Deadlines are set by the court. Some deadlines are set by the rules. Some deadlines are set by statute. Now, what happens at the time of trial is your client comes in, and I'm talking about from the defense perspective. Client comes in, we're there at the table, and at the judge, if the judge has not already given us the sheets that are talking about the jurors, right? The jury questionnaires. Some counties, you get the jury questionnaires days or weeks in advance. Some counties, like Marion County, on criminal cases, you get them about 15 minutes before they bring the jury in, which is, you know, kind of insane. So that 15 minutes, you're looking at these actual questions that jurors have responded to and given answers to. And this is in Marion County. And you're trying to figure out, okay, who's looking good, who needs to be struck, and all this kind of stuff.
Hey, Mark.
Yes.
Who does the questions for the jury questionnaires?
The courts can do those questions. Most of the time, they're already done from years ago, and they come out through a jury pool, and there's just standard questions like name, age,
Convictions.
You know, had any convictions, know any law enforcement. It's a pretty standard thing. But if the courts wanted something specific, they could craft their own specific type of questions that would go out to the jurors.
Okay.
And they get the little sheet saying they have jury service. When they come in to the jury pool, then they end up filling out, you know, the questions, and they take those questionnaires and then give them to the court.
Okay.
So, and most of the time, someone asked me yesterday, I think, how are they picked? In Marion County, in most counties, you're looking at the driver's license. And they're looking, so basically people that have driver's license.
Voter registration?
You know, voter registration, registered voters are some of the ways that the jurors are picked for jury service. So
for the pool. For
the pool of people that will be selected or potentially selected for service. That is how they're selected. Now, getting to actual selection of the jury, right? How are we going to actually select who is going to be sitting on the jury? I call it a deselection process because you don't get to say, hey, I like her, I want her on the jury. I like him, I want him on the jury.
Yeah.
Mainly the way it's done is you strike the people you do not like.
Do you start with the jury list? The questionnaires?
Yes.
Okay.
So with the questionnaires, I start looking at people that I think will not be receptive to our argument.
Okay.
And those are the ones I kind of put either X or a little question mark on or something like that. And then obviously when we start doing the questioning of the jurors, potential jurors, I go a little bit deeper on whether this is the person that I want to be on the jury or not. And if I don't like that person, or my client who has final say-so, I always give my client final say-so about who they want on the jury or who they want off the jury. And if they want somebody off, then I go ahead and say this is the person I want. And that's why I call it deselection process, because you actually mark off or tell the judge, strike whatever of the jurors that you don't want on there. You don't get to keep people that you do like. And
you normally don't like lawyers, right?
It depends on the particular case, right? If it is a criminal defense attorney, I would think that most prosecutors would not want that person on there.
Yes.
If it was me, I would want that person on there because I think that they would understand the law, that they would understand what reasonable doubt is, beyond reasonable doubt. I think they would understand that better than most private citizens would. So if it was a prosecutor that was on there, obviously they would probably be removed for what they call cause. And removing someone for cause means that this is someone that there is a legal basis that why they couldn't be on there. They're law enforcement, they're an agent of the state, which would be like a prosecutor. They, the relationship, because maybe they know the victim in the case. Something like that would prevent them from actually serving on the jury. Once we get through that part, then it is opening statement time. And, the prosecution goes first with their opening statement, then the defense goes opening statement. Then you have the arguments. Then you have the questioning of witnesses, the direct examination, the cross-examination of witnesses. The state would go first. They would present their case, call a witness, do the direct examination. Defense has opportunity to do cross-examination. And we repeat that process till the state says they rest. And then once they rest, the defense has opportunity to do the same, call witnesses, and then the state would have an opportunity to cross-examine those witnesses, and then we would rest. And at that point, you get into the closing argument. And after closing argument, and the judge gives jury instructions, again, at that point, they go into deliberations. And if you're a defense attorney, you're probably hoping for a not guilty verdict. And so that is kind of like a short summary of what the jury kind of process is. Obviously, there's more detail. There's more motions that are being filed. There's a whole lot more stuff that goes on with the jury process. But that's kind of like a short summary of it.
Yeah. So one thing I think a lot of people have a misconception about is whether or not the defendant's going to testify and why.
Oh, yes.
If you want to hit on that.
So, in America, because this is not, a country with no laws, the Constitution provides that the accused has a right to remain silent. Most people have seen the TV show Miranda, you have a right to remain silent. And we've also done a Circle City News show that talked about the right to remain silent. So with that, not only carrying over for arrest, it also carries over for you at trial. So if someone's at trial, they do not have to present a defense. They do not have to testify, and that should not be held against them. Now, one of the things I always explain to people is, look, we're at trial because my client has said they didn't do it. He's not guilty. So if someone gets on the witness stand and says, hey, I didn't do it, some jurors may think, well, of course, that's what they're going to say. They're going to say they didn't do it. That's what they're going to say. Or someone's going to say, well, he looks nervous. He looks like he's lying or something like that. Maybe just because he's scared. People don't go to trial every day. People are not in court every day. So it could be a very intimidating experience. And you have to understand that the prosecutor, for the most part, is very skilled at their jobs. And they do this for a living. So they know how to cross-examine witnesses, and they know how to ask questions to make people get tripped up.
Even when they're being honest.
Even when they're being honest, So that is another thing that can make someone look guilty and the jurors not give them the benefit of the doubt. Obviously, if the person has nothing to add, like, hey, I didn't do it, I wasn't even there, I don't know, what's the even point even calling them on the witness stand and say, hey, I didn't do it, when they've already said they didn't do it?
Yeah, I always tell my clients, if you don't get up on the stand, nobody can judge your credibility.
Right.
Once you get up there, they can. And the other thing to consider is, defendants or respondents in the juvenile world, they have the right to appeal. So the appellate court defers to the trial court's judgment on the credibility of witnesses. So if you don't put your client up there, they can't be like, oh, well, the trial court must have thought your client wasn't credible.
Right.
So a lot of times I have to advise them, if we appeal this, they're going to defer to the trial court as to whether they believed you or not. So there's always a danger in putting your client on the stand. I think a lot of people kind of are like, oh, why didn't the defendant testify? They must have something to hide. But really, most lawyers don't put their clients on the stand because, frankly, like you said, they don't always have anything to add outside of the evidence that you've already presented.
And, when the burden is upon the state of Indiana in a criminal adult case to prove their case beyond a reasonable doubt, if they have not met that burden by the end of their case, when they have rested, then at that point, there's no need to even really present any more of a defense because they've not met the burden. And the only thing you can kind of do in some cases is screw it up by doing a whole bunch of other stuff. And it's like, well, I thought they didn't make the burden, but then when you got in and started doing this other kind of stuff, I lost credibility in what you were doing. I had a case that my client did testify. They have the constitutional right whether or not to testify. We do not have control of that. If they want to testify, they can. If they don't want to testify, they don't have to. So my client chose to testify, and after the trial was over with, he was found not guilty. The jurors said, there was a point when your client was testifying, I thought, oh man, he's guilty, because we were all ready to vote not guilty after the state rested. Like there was nothing else you needed to do. But my client, and I don't know exactly what he said on the witness stand, but they thought, oh, when he said that, it made him kind of look guilty. But then, he said some other stuff that kind of explained what he was talking about or whatever. So there was a case that obviously I had no clue that after the state rested, they were going to find him not guilty. But we just went ahead and my client wanted to testify and it worked out. The last case, well, one of the cases I tried a few months ago, so the jurors, after they found my client not guilty, said, I'm glad you put him on the witness stand because we really wanted to hear what he had to say about what happened. And he answered the questions. He said basically what we thought he was going to say. And we're really glad that you put him on the witness stand.
See, this is why you want criminal defense attorneys on the jury, because people have a hard time when defendants don't testify.
Right.
They think they're hiding stuff.
Exactly. And this client was totally innocent. And I won't go on all the details of that particular case because that's for another day, another episode. But I'm glad that the jurors here in Marion, it was a Marion County case, were able to get in there and see that he was innocent. Now, Audrey does juvenile type cases. That's kind of her area of law. I've never done one. I don't do that. Their process is a little bit different. It's my understanding, if I'm right, they don't have a constitutional right to a jury trial for a juvenile. So let's
talk about that. I want to hit on one thing before I forget.
Sure.
Though. When we're talking about our clients testifying, it is a unique situation when you're talking about a kid getting up on the stand, because like you said, you get a skilled prosecutor or a not skilled prosecutor. Either way, you get somebody questioning you, and kids, man, they get so nervous. They get terribly nervous. I think the worst situation I've had is, a kid that was so scared. We had already basically lost the case, but he wanted to get up on the stand and he basically just admitted to it.
Oh, wow.
Kids are just a whole different ballgame when they go up there. I mean, you never want to put somebody up there unless you're sure they can handle the pressure and they're going to be consistent, because they can get really nervous. And we've talked about why there's dangers in people questioning children. So I'll leave it at that. But that's a unique to juvenile situation. But their trials are paralleled, but there's a lot of difference. The biggest difference is obviously what you just mentioned, is that they're seen as quasi-civil, quasi-criminal. So we use the same body of case law, the same statutes, the same arguments, the same procedures as an adult criminal trial, but kids don't have a right to a jury. So they're just all bench trials. I mean, I feel like there's always, pros and cons to that. Judges generally understand the law better than people.
I agree.
But those occasional like factual arguments are a little bit harder to make. The sympathy level is a little bit down. But yeah, you don't have the juries, you don't have the jury pools, you don't have the questionnaires, so you're just relying upon your judge. It's important, and I like have to toot my own horn here, but it's important that you get an attorney that knows your judges for that reason. You don't get the questionnaires, you don't know about these people. So if you're hiring somebody who's never been in front of one of the juvenile court judges and you don't know like what they're looking for, that can be a huge hurdle. So just as a lot of things are done behind the scenes in adult court, like your preliminary motions in limine, your basically any motion, even suppression hearings, are generally done during trial at a lot of juvenile courts. Some judges will do them, especially in donut counties outside of Marion County. Some judges will do like your suppression motions first, but a lot of Marion County courts just do all of the motions as they go because the judge is able to sort those things out. You're not tainting a jury. So there's a lot more informalities to juvenile trials. Because you're just in front of the judge, and the judge is very understanding of the issues in the law. And that includes motion practice as well as not having the extra, day or two of jury selection.
Right.
So often people are very surprised at how quick juvenile trials go. Like a simple misdemeanor, lower level felony, I mean, you could be talking about maybe a half day at most.
Oh.
And then when you get into major felonies, I mean, sometimes you're surprised if it goes more than a day. The more serious, obviously, you'll get a couple days in there. But yeah, they move very quickly because you don't have to do a lot of the things that you have to do with the adult court, which is like sequestering the jury and advising and all of those things. So, procedurally, it goes pretty similarly to adult court. Most juvenile courts don't do opening arguments. You can usually request them, and judges are happy to do that. The judges, again, are just more easily able to understand the issues without having to do that. Normally, you're preparing a jury for, here's what the case is going to be, but the judge already knows. So the informalities include often sitting, not doing openings. This sounds nice, right?
Right. Although I like doing that stuff, so it would bother me not being able to do that.
I mean, the more you do, the more theatrical you get. They do enjoy like some formalities.
Okay.
But yeah, as far as presentation of the evidence, it's still state goes first, calls their witnesses. So we're called the respondents in juvenile court instead of the defendants. Basically, we have equal names for everything. In fact, the trials are called fact findings. Sometimes we'll call them trials because that's basically what they are, but they're called fact finding hearings, which is a much nicer way to say like, do you find my client, true or not true, not guilty or not guilty? And the judge is to look into the facts to figure it out instead of like an adult trial sounds so much more intense, like, oh, you're on trial for this and we're going to find you guilty or not guilty. So it's just equivalent terms. So the state goes, the respondent goes, and then the judge will usually we do closing arguments though. Yeah, obviously.
Okay.
But the judge will do one of two things. They'll either take it under advisement, which is the equivalent of waiting for your jury to come up with a ruling, and issue, a ruling later on, which is pretty regularly done in the higher level cases or cases where there's a lot of evidence for the judge to review. Or oftentimes the judge will just issue the ruling from the stand within like 30 seconds of completing your closing argument. So, so the procedure's the same, the case of law the same, but the biggest difference is it would be the equivalent of like a bench trial. A lot more informalities, a lot faster, and then you don't have to worry about sorting out the legal issues for the jury because the judge knows the law. You just need to remind him of what it is and make a record for possible appeal. So that's the juvenile process, but there is a big issue that I need to add in. So the big issue that I need to add in is where our jury, adult court, and I'm going to say adult court, not adults when I talk about this, and then the juvenile intersect, and that is when a juvenile who is 16 or older and charged with certain major offenses, rape, robbery, arson, murder, I'm forgetting one. Rape, robbery, arson, murder. But the higher level felonies, there's a statute called the direct file statute. So with certain juveniles 16 or older, they automatically get filed downtown in adult court. So even though they are technically a juvenile, the adult court has jurisdiction. And in the adult court, you're entitled to a jury trial.
Right.
So if you are direct filed into adult court, you will go to this side.
Yes, and you will get a jury trial. Now, there are things that we don't have time to talk about today that there can be, a waiver to adult court, reverse waiver, I guess, and things that are really complicated. I do want to explain, or have maybe Audrey explain the difference between a jury and like a bench trial, because we kind of use those terms thinking that people know what they are. But some people may not know, like, well, what's the difference between a jury trial and a bench trial? Okay.
So the short version of the waivers that you just talked about that could take up like 4 different episodes is that's really just a procedure to decide where the trial will be held. So like you said, that's a whole nother topic. But the adult court jury trials is being judged by a jury of your peers, hopefully, depending on how your lawyer does it. But that is how many people generally would sit on a criminal jury.
Okay. Well, when we say peers, that's another little trigger word for some people, because they think, well, these people are not my peers because they're not African American or they're not from my neighborhood. Really, when they say peers, it's for a state county trial, like Marion County. It would be people from Marion County. It doesn't mean that they have to be from your same neighborhood or they have to look like you or whatever. It's just people from Marion County. That is the peers. And you're looking at a 6-person jury for like a misdemeanor to like a F6, 12-person jury with probably 2 alternates.
Say alternates.
If you have a major felony type of case. So that's what you're looking at with a jury and the selection process that I talked about earlier when it comes to a jury trial.
And the bench trial is that the judge that's presiding over your case hears that case. And that's why I say the formalities are much lower, because you're usually in a very small courtroom, and then it's just the judge at the bench, and the judge makes the rulings on all of your motions and all of your requests and all of your objections, and then they also issue the ruling. Right. So they're basically in charge of everything. You don't get a second opinion. You don't get a panel of 6, 8, 10 people to determine. You don't get the guy that lives down the street from your neighborhood. You get whatever judge you're in front of. And then you can always file for like the presiding judge if you have a lower level magistrate that you just don't think would be as receptive to your case. But other than that, there's not a lot of remedies to get you out of in front of that specific judge, especially if they are a judge. You can't do a lot unless they have a legal basis to get out of that courtroom. So you don't get to pick. Right. You don't get to strike.
Now, I will say that in the adult court, you can have a bench trial. That there is, you can have a case where it's basically automatically kind of set for a bench trial because it's a misdemeanor and you have to ask for a jury trial. Or if it's a felony, it's basically automatically set for a jury trial. But you can file a waiver of a jury trial, and if the state agrees and the court agrees, then you can have a bench trial. And it's similar to what Audrey was talking about, where you would present your case to the court and then the court makes a decision. Sometimes people do that in the adult defense, mainly if it's a misdemeanor. They'll sometimes do the bench trial because it get done, like in a day, a lot easier, a lot quicker if it's kind of fact sensitive or law sensitive. Strategic reasons why someone may want to go ahead and do a bench trial instead of a jury trial. Mm-hmm. And then even on some of the more higher level felonies, sometimes people who know the judge, and when we say know the judge, that doesn't mean that they have this kind of intimate relationship with them. What we're saying is they've been in front of the court or they've studied this particular court and know the court procedures and some of the rulings that the court does. In that particular case, they could say, this judge is known to do a lot of trials or a lot of bench trials. Mm-hmm. And normally this is how the judge rules on certain matters. And when that happens, someone may say this may be a better case to do a bench trial because of the legal issues involved, or the facts are so ugly that if a jury hears it, a jury is going to be appalled and they're going to think, oh, someone has to pay for this. And so we're just going to find guilty, and we don't understand all the legal mumbo jumbo talk. Yeah. So it could be better where the attorney decides with the client that, hey, I think this may be a better case that we waive jury because of the issues involved are better for a judge to kind of understand and decide,
I know we're running out of time, but I really want to talk about one more thing real quick. You mentioned that it can be much faster, not just as far as how long the trial takes, but you can also usually get a bench trial much more quickly than a jury trial. Yeah. And so I just want to point out that in juvenile cases, you actually have the right, if your client is incarcerated, to a trial within 20 business days, which is insanely fast. Obviously with a jury, you still have a speedy trial, right? But a lot of times, especially with released clients, you can usually get in the door much faster if you don't want to wait for the jury pool and the open dates and the extra time.
Yeah, definitely. If you're going in a bench trial, generally speaking, it's going to be a lot easier for the judge or a magistrate or whoever to hear it. Is going to be a lot quicker and easier than if you are waiting for a jury trial date, because especially with COVID, the jury trial calendar has just been backed up. Mm-hmm. And now there's the floodgates are open and there are a lot of juries that are going, and they can usually only do one jury at a time. There's a new building, the CJC, Criminal Justice Center, and they may be able to do multiple juries and calendar. I don't really know how that's going to work out. It's going to be interesting to see. Mm-hmm. But apparently some courtrooms, or maybe all the courtrooms now, can run dual calendars. They can have their general court calendar and they can have this jury trial going all at the same time. So yeah, definitely that would be helpful. So this is the Circle City News. We are so glad that you were tuned in for another episode, and we look forward to seeing you again next week. Bye.